Prime Ministers come and go, but constitutional plumbing endures, and this week the slow valves and the sluices around royal scrutiny creaked open. MPs are exploring whether to test the boundaries of convention and drag the Duke of Hazard, as insiders apparently call him, into the disinfecting light of Commons debate. The trigger is not a new allegation, but a very old lease, a 30-room grace and favour mansion held in Windsor Great Park on a peppercorn rent, now revealed to have been obscured in the land registry copy. That concealment was technically lawful, yet highly unusual for such a basic financial term, and it has become the lightning rod for public irritation. The parliamentary question is simple. Can MPs examine Andrew's conduct, his lease, and the status of his titles? The answer procedurally is yes, but only if they do it in the right way. Erskine May is explicit. You cannot casually attack the conduct of the sovereign, the heir, or other royals in ordinary debate. If you want to do that, you must anchor criticism to a properly drawn substantive motion, and that is why an opposition day slot suddenly matters. It supplies the procedural raft on which the House can float an argument that would otherwise sink on contact with the rules. What in law could such a debate do? Well, first, the dukedom. There is no neat administrative switch to flick. For a peerage of the realm to be removed, Parliament must legislate as it did in 1917 when it created a mechanism to deprive enemy peers during the First World War. That statute is a museum piece, but the principle remains. Deprivation of an hereditary peerage is a matter for primary legislation or a bespoke act. Motions can pile on pressure, only a bill bites, but the precedent is set. Secondly, the princely styles. Who is a prince or princess is not folklore, it is set by letters patent. George V's 1917 instrument restricted HRH and prince or princess to the children of the sovereign, the male line grandchildren of the sovereign, and at the time the eldest son of the Prince of Wales. In 2012, Elizabeth II, the late Queen, extended HRH and the princely dignity to all the children of the then Duke of Cambridge. Taken together, these rules explain why Archie and Lilibet became prince and princess on the accession, and why Beatrice and Eugenie are princesses even though they're not working royals. These are legal styles, not rota allocations. Changing them would require fresh latest patent under the royal prerogative, almost certainly with ministerial advice or an act of parliament. Rumours swirl about future contractions, and the Twitter sphere is alive with rumours and specific plans, but as of today there is no new legal instrument. Third, the property. The controversy is not that the rent is low, a peppercorn is routine in long leases, it is that the public copy hid the peppercorn altogether. When you combine that with a pledge to put duty first, the optics sour. Hence, the pressure for Andrew to accept a relocation with talk of compensation for sunk costs and a smaller residence. Reports that he is in advanced talks to quit Royal Lodge are politically helpful, yet until a deed is signed, politics will keep gnawing. Now for the wider frame, the politics and the tabloids prefer to crop out, there are really three constituencies here. First, Parliament, which is within its rights to demand transparency about the cost of the use of the Crown as state assets and to test whether the honours system has adequate teeth. Secondly, the palace, which must balance mercy to a brother with signal sending to the public. And third, the public itself, which is sick of the feeling that there is one rule for court favourites and another for everyone else. That is why a redacted lease provokes more ire than a legal lecture ever will. What about Prince Harry and his children? What about Beatrice and Eugenie? Legally, their styles flow from those later letters patent and from the fact that they are the sovereign's male-line grandchildren in Harry's case and the sovereign's nieces in Beatrice and Eugenie's. The idea of stripping titles from non-working royals is a political project, not a legal fait accompli. A future monarch could narrow eligibility by new letters patent, but that would be a significant constitutional act with diplomatic and family consequences that go beyond a week of headlines. As for Parliament, it could legislate on titles, but that would be an unusual incursion into the prerogative and would invite debate about where to stop. The practical upshot is this: speculation is cheap, instruments are hard. What should MPs actually do next? If the House wants to be serious, it should table a carefully phrased, substantive motion that avoids personalities and demands evidence under oath from the Crown Estate and the leaseholder about public value, maintenance liabilities and any public costs. The House could then invite ministers to review the framework for redactions in land registry filings to prevent the concealment of fundamental financial type private individuals occupying public assets. That is constitutional housekeeping, not populist theatre. If they want to go further on titles, they should commission the Commons Library and the Cabinet Office to produce option papers on sanctions short of deprivation, a suspension of the use of HRH by warrant, removal from orders of chivalry by the Forfeiture Committee. Prince Andrew's flag has been removed from Windsor, and a formal protocol tying the use of styles in public engagements to a published definition of public service. None of that requires a cultural war. It requires tidy drafting and quiet steel. One last point on proportion. It is right for Parliament to insist that those who benefit from the aura of public service actually serve the public. It is also right to notice that when our politics becomes addicted to the sugar rush of princely scandal, while missing the protein of statecraft, there is something worrying. Today we are transfixed by a peppercorn and a lease. Meanwhile, the world burns hotter, democracies creak under strain, and alliances face stress tests that are not theatrical, but are existential. To that end, we should ask, as Rory Stewart asked the other day, he said, Trump is destroying the world and we are focusing on Andrew and stuff that happened long before Trump and Brexit and Putin's invasion of Ukraine. We should have more perspective, frankly. And Rory Stewart, of course, is absolutely right.